Right. Hello, everyone, and a warm welcome to the 16th webinar in our series. My name is Anuth Naushan, Project Manager of Courage to Act. Courage to Act is a 2-year national initiative to address and prevent gender-based violence on post-secondary campuses in Canada. It builds on the key recommendations within Possibility Seed's vital report, Courage to Act, developing a national framework to address and prevent gender-based violence at post-secondary institutions. Our project is the first national collaborative of its kind to bring together scholars, experts, and advocates from across Canada to end gender-based violence on campus. A defining feature of our project is our free professional webinar series, where we invite leading voices to discuss key concepts and share promising practices on addressing and preventing gender-based violence on campus. Supported by Caucus, these webinars are also a recognized learning opportunity. Attendance at 10 or more live webinars or our National Skillshare series will count towards an online certificate. Our project is made possible through generous support and funding from the Department for Women and Gender Equality, WAGE, Federal Government of Canada. We begin today's webinar by acknowledging that this work is taking place on and across the traditional territories of many Indigenous nations. We recognize that gender-based violence is one form of violence caused by colonization to marginalize and dispossess Indigenous peoples from their lands and their waters. Our project strives to honor this truth as we move towards decolonizing this work and actualizing justice for missing and murdered Indigenous women and girls across the country. I'd like to pause now and invite everyone to take a few deep breaths with me, because this work can be challenging. Many of us may have our own experience of survivorship and of supporting those we love and care about who've experienced gender-based violence. A gentle reminder here to be attentive to our well-being as we engage these difficult conversations. And before I introduce our speakers today, a brief note on the format. Our speakers will present for about 45 minutes, and I invite you to enter questions and comments into the question and answer box, and I will monitor this, and together we will pose these questions to them at the end. The Q&A will happen in the last 15 minutes of the webinar. At the end of this webinar, you will find a link to the evaluation form. We'd be grateful if you take a few moments to share your feedback, as it helps us improve. This is anonymous. Following the webinar, I will also email you with a copy of the evaluation form and a link to the recording, so that you can view the webinar again and share with your networks. We have two wonderful speakers today. Unfortunately, Chandra Pasma was unable to join us today, but we're very grateful for her expertise and all her work in bringing this webinar together. So I'm pleased today to introduce you to our speakers, Dr. Brenda Austin-Smith and S.E. Codjoe. Dr. Brenda Austin-Smith is a professor and head of the Department of English, Theatre, Film, and Media Studies at the University of Manitoba, Treaty 1 Territory. Brenda also serves as a president of the Canadian Association of University Teachers. She teaches and writes on a variety of topics, such as Canadian women's filmmaking, documentary, and film and emotion. Brenda was involved in the organizing of what is now CUPE 3909 when she was a grad student at the University of Manitoba. As a teacher there now, she continues to act and advocate for publicly funded, accessible, high-quality post-secondary education for all. And S.E. Codjoe is a lawyer at Turnpenney, Milne, LLP. Her practice focuses on workplace law, including employment law, human rights law, training, investigations, and mediation. She's a previous vice chair at the Human Rights Tribunal. S.E. taught business law and labor and employment law at Ryerson University. S.E. was legal counsel, employee labor relations at McMaster University. She provided advice on employment and labor matters. She was in-house litigation counsel at the Ontario Nurses Association. S.E. also routinely litigated grievance arbitration cases and provided advice on human rights matters. S.E. is an executive member of the OBA's Labor and Employment Law section. She was a Toronto Regional Director on the OBA Board of Directors and member of the Governance Committee. She's a past chair of the OBA Equality Committee, and from 2009 to 2013, she was an executive member of the CBA Labor and Employment Law section. She has served as a secretary and director of professional development for the CABL. And in 2018, S.E. was named as one of Canadian Lawyer magazine's top 25 lawyers in the area of human rights. And in 2019, she was awarded a Lexpert Zenith Award as a change agent in law. So we have a really wonderful and brilliant lineup today, and I'm excited now to turn it over to our speakers.
Thank you very much, Anuth. Thank you also to Possibility Seeds, Courage to Act, and the federal government for their support of this important work. I'd also like to echo thanks to Chandra Pasma, researcher from CUPE, Canadian Union of Public Employees, who took the lead on preparing the slides and the presentation that she and I intended to do together, and I am now doing on her behalf. So beginning with the role of unions in addressing gender-based violence, I did want to say that throughout these slides and my comments, the term sexual violence and harassment does turn up because sexual violence and harassment, or SVH, turns up in many union collective agreements and documents. It does, I think, mean that what I'm going to say here today has relevance for the larger landscape of gender-based violence, as Courage to Act has urged us to consider this, but it's a matter sometimes of these documents catching up with these developments. So to begin with the role of unions. Unions are bargaining agents and social agents. They protect the rights of workers and they promote social justice through collective bargaining, through the grievance process, and through their influence on institutional policy, that is policies at universities and colleges, and their influence in the realm of public policy. Legislation gives unions specific rights and powers to act, to bring employers to the table during bargaining, to deal with systemic problems, to agree violations of collective agreements, which includes arbitration or judicial review in some cases. And unions don't just defend the rights of their own workers, they fight to protect the rights of everyone. I can give some examples to you briefly. Unions have contributed to collective advances in equity and in human rights, in hiring practices, in the enactment of same-sex marriage laws, following successful labor arbitrations and tribunals, and in expansions of employer accommodation responsibilities. So we'll move on to the next slide. And in the case of gender-based violence, unions play several roles. They support workers who have experienced gender-based violence and harassment. They represent workers who have been accused of sexual violence and harassment, and they ensure that the investigation and disciplinary processes undertaken are fair and follow the rules. Unions ensure that all workers have the training that they need to prevent and respond to incidents of GBV, and they bargain accommodations and supports for workers who have been affected by sexual violence and harassment. They also ensure employers abide by their legal obligation to provide a safe workplace. Unions do have a special legal duty to represent in these situations, which is not about picking sides or preventing offenders from being disciplined or minimizing egregious behaviors. But unions do have a legal obligation to ensure that all members of the union have representation and that they are treated fairly. We'll move on to slide 3. Our sector, the post-secondary education sector, is highly unionized. About 75% of education workers in Canada belong to a union. Most universities and colleges have at least 3 unions or union locals representing workers on the campus. Faculty associations, unions representing student workers, unions representing support staff. And on many campuses, there are even more, with divisions between permanent and contract faculty, graduate students and postdocs, inside support workers, and outside support workers. Plus, there are often unions that represent services that have been contracted out, such as food service workers or custodians. And some professional associations that are not unions, but fulfill some of the same functions as unions, exist for people in senior management. And I'm thinking here of the example of the University of Toronto, which has, I believe, 15 different bargaining units. So in all of these situations, the collective agreement between all of these unions, all of these bargaining units and the employer is paramount. Institutional policies cannot overrule collective agreements. Slide 4, please. So still situating workers in the campus community. Not all workers have the same power or privileges on our campuses. There is a distinct hierarchy of worker power. First, there is the central administration or management, the president of the university or college, vice presidents, deans, associate deans, etc. They are not unionized. Then there are tenured faculty. They're at the top of organized workers. Contracted out service workers and precarious workers, those people who work on temporary contracts that may or may not be renewed from time to time. They're at the bottom. And there are very different contexts for this work. Permanent faculty, for example, tend to move in and out of management roles and management functions. Contracted out service workers may be told that they really are not part of the campus community, and their employer may change every few years when the contract for which they are hired to provide services changes hands. For example, you might notice on your campus that food services are provided by Aramark or Chartwell or Beaver Foods, and then it might switch from year to year. And student workers are another thing to consider. There is a high turnover in leadership in unions representing student workers, and therefore those workers are less likely to have knowledge of their rights as workers. So a significant proportion of workers on our campuses are also students. So I have a little infographic here that gives you a sense of the relative distribution of various campus workers. And this is on the York campus, York University. You can see that full-time staff, that's full-time support staff, 2,700 full-time support staff, they're non-teaching. 2,100 plus teaching assistants, those are students who are also employed and are members of a union. 1,900 contract faculty, those are people on those precarious short-term contracts, sometimes renewed, sometimes not renewed. And 1,600 plus full-time faculty, that includes people who are on the tenure track or people who already have tenure. And then 48 librarians, again, some of whom will be full-time, some of whom will be part-time. So there's quite a large distribution there. But if you look across all of those blocks, you can estimate that somewhere between 30 to 40% of all of those employees are students. So it's really important to recognize the overlapping identities of workers on our campuses. Many people are both students and workers at the same time. And there is this fluidity of roles, responsibilities, and power. A course instructor could also be a postdoc and might have to report to their own thesis supervisor from time to time. A teaching assistant might also have an on-campus job in food services or another service role where their supervisor in one moment is actually one of their students the next. An instructor who does not have tenure may be very vulnerable to any kind of student complaint. And we just can't assume that complainants will figure out where they belong and what processes they are entitled to, or how the many relevant processes work or don't work together for them. That's why it's best for the institution itself, the college or the university, to develop materials that can be handed out to people who report incidences of GVH that cover how various policies apply to a variety of possible situations. And I'll give you some examples of those possible situations. A student complainant and a respondent who is a unionized worker, a complainant and a respondent who are both from the same union, a complainant and a respondent who are from different unions, both unionized but different unions, or a unionized worker and a non-unionized worker, or a member of the public visiting campus who is either the complainant or the respondent. Slide 7. So we need to recognize that workers on our campuses are not just involved in addressing gender-based violence in the role of either complainant or respondent. They are also first responders, or they're bystanders. They receive disclosures. They provide representation to a complainant or to a respondent, and they have a really critical role to play in prevention. So generally speaking, there are 7 processes that could apply to any given incidence of gender-based violence. There's the institutional policy with its own process for interim measures, investigations, adjudication, and discipline. There are alternative resolutions, mediation, alternative dispute resolutions, restorative justice in some cases. There's also the grievance process. There are workplace health and safety investigations that might be initiated by the registration of a complaint. There are internal union processes. If somebody from a union active in one of its committees is a respondent or a complainant, the union would have its own work to do. There are Human Rights Commission actions that might be available and appropriate. And finally, of course, there's the criminal justice system. And sometimes a certain process must be followed due to provincial legislation or the collective agreement. For example, in some provinces, an incident in the workplace must result in a health and safety investigation. In cases where a certain process is not dictated by law or not dictated by an extant collective agreement, the power should lie with the complainant to choose which process to follow, with the institution respecting that choice and the union providing support and representation as necessary. We have to recognize that it's possible to pursue more than one process, although some of them may not be combined in certain moments. So here are some recommendations for our universities and colleges, for administrators who might be on this webinar. Institutional policy should apply to all members of the campus community, should not apply exclusively to students, and it shouldn't dictate which process workers need to follow, unless, of course, there is a legal or collective agreement requirement. Complainants should not have to pick just one facet of their identity. Students should be able to get protection as workers, and workers should be able to get accommodations as students. Institutional policy should make reference to the existence of collective agreements and state that they cannot be overridden by an institutional policy document. And it's really important that policies be in plain language. Not all members of the community can decipher legalese. Consider having additional materials available that can be provided to complainants and respondents, letting them know what their choices are and how different processes might work if you are a student complaining about a unionized worker complaining about a member of the same union, a unionized worker complaining about a member of a different union, or a unionized member complaining about a non-unionized worker, and so on. So institutional policy needs to provide guidance on more than just what complainants do. What do faculty and staff do when they receive a disclosure? When do bystanders or disclosure recipients have a duty to report? What supports are available to someone who witnesses an incident of gender-based violence, or someone who helped respond to an incident? Within your institutional policies, there are key moments where you need to be thinking of workers and not just students. When doing a harm assessment, for example, at your college or at your university, include staff in your assessment. When thinking about supports for complainants and respondents, also think about supports for witnesses and first responders? Were staff, for example, asked to come in and clean up after an incident? Were they given a warning about what had occurred? Were they referred to support services afterwards? Were they given access to time off for mental health? Who is receiving this disclosure? What kinds of supports are available? Is it always the same workers, often women or gendered female? Is it professors, cleaning staff, others that you don't think of as frontline staff, but whom students see and interact with every day? Does everyone have the training they need to respond in a trauma-informed way? Do they know how to direct the survivor, where the survivor should go, and what the survivor needs to do? Do they know about the duty to report, the ability to file a third party or anonymous complaint? So institutions need to be very clear when advising complainants and respondents about the process, and that they are allowed and in fact encouraged to have union representation if they belong to a bargaining unit. Institutional policy should also have a very clear statement on record keeping and disclosure. Be clear who will have access to these documents and for how long will they be kept and where will they be kept. Institutions also have to be aware of implications for grievances. The union has jurisdiction if a decision involves discipline, so the union must be informed if a decision involves discipline or somehow affects or impacts employment. Discipline or sanctions cannot be based on anonymous complaints or anonymous materials. The union has to be kept informed at every step of the process. Privacy law does allow an employer to redact parts of a final decision after an investigation is completed, but not to fully withhold the report. And if a decision goes to a grievance, the local will end up with the full report in any case, because otherwise they can't perform their legal duty to represent and to represent all members fairly. So if an institution denies access to a report at the conclusion of an investigation, they will almost certainly lose the grievance or end up in court for a judicial review. So recommendations for administrations when it comes to working with unions on your campuses. Involve unions in consultation and review. Make sure that you're consulting and communicating with your unions. They should be included as equal partners in developing and reviewing policies and procedures. Work with unions to ensure that all members have training that they need to prevent and respond to gender-based violence and harassment. The best training will not be imposed on workers from above. Training needs to take into consideration the various roles and responsibilities of different worker groups and ensure that they have what they need to carry out the tasks described in that training. And unions, of course, have a critical role to play in prevention. Workers are an important source of information on where the safety risks lie. They know the areas where lighting is poor, where people work late but the doors aren't locked, where offices don't have windows so no one can see what is going on. In normal times, pre-COVID, when students are on campus, they also interact with workers all the time. Workers can intervene and redirect when problematic behavior is witnessed. And finally, there's collective bargaining. If institutions want reference to the institutional policy in the collective agreement, you need to bargain it. And you also have to be prepared to negotiate accommodations and mental health supports for vicarious trauma for those involved in responding to incidents of gender-based violence. And now recommendations for my side, for unions. Unions need to provide training for our locals and our members on how to effectively represent members as both complainants and respondents in incidents of gender-based violence. For instance, we have an obligation to have separate representatives when both sides of a case are members of the same union, with a firewall between the two sides. Unions need to understand the different types of processes involved in any one of these cases or situations, and not try to replicate one process in another venue simply because we're more familiar with it. For example, we shouldn't be treating investigations under an institutional policy as if they're grievances. We need to understand that survivors find certain types of behavior very traumatizing and try to carry out our role in a trauma-informed way. Slide 14. So recommendations also for unions in bargaining. Be willing to bargain in references to the institutional policy and how it interacts with the collective agreement. Negotiate accommodations and mental health supports for everyone affected by gender-based violence, including those who are involved in responding to incidents. We think here of examples from the airline sector, something like critical incident leave, an automatic paid day off for workers who have experienced certain kinds of incidents on the job. And my final slide. Unions are important campus partners in working to end gender-based violence on our campuses and everywhere. Unions need to develop and revisit their own internal policies and procedures for their members and for their union bodies, for their executives, for their committees, for their bargaining teams, for example, and to take a stand against all forms of gender-based violence. But because of their legal standing, unions also have the tools, the tool of collective bargaining, the tool of the grievance procedure. Unions have capacity for political campaigns. They have a history of building effective coalitions with other campus and community groups to make a difference. Thank you.
Great, thanks very much, Brenda. So in terms of my particular presentation, as you can see, the focus of the presentation is going to be on workplace investigations. Before I dive in, I wanted to sort of set the table a little bit so that people understand the scope of this particular presentation. So with respect to the presentation, obviously I'm a lawyer who conducts workplace investigations. I also do training and mediation. So I do this work on a routine basis. What I can tell you with confidence is that the topic of workplace investigations is quite broad and deep. And this particular presentation can really only be a sort of high-level overview of the aspects of workplace investigations that we engage in and the things I think are most salient or most relevant for this particular presentation. So all that to say, there's lots to cover, but I won't be covering that lots because we have limited time today. Okay. So in terms of where we're going with the presentation, here's an overview. So I have a number of objectives in terms of what I'm hoping that you'll learn from this particular presentation or what you'll get from the presentation. The first being this, how to approach gender-based violence issues. Secondly, the role of bystanders, colleagues, peers, and managers. Third, the investigation process and its purpose. Fourth, the role of people such as myself who conduct investigations. And fifth, where gender-based violence issues can be addressed. Now, again, by way of caveat, some of these concepts have been touched on very lightly by Brenda in her previous presentation, and I'll go a little bit deeper on some of these concepts. But again, the substance of all of these is much deeper than I can cover in this presentation, so I commend you to look at some of the resources that we'll provide after this presentation is over, and to explore other sources to get more in-depth information. Okay, next slide, please. Addressing gender-based violence. Next slide. With respect to addressing gender-based violence, there's some best practices that you should be aware of when it comes to these issues. The first has to do with leading with sensitivity and compassion when it comes to dealing with somebody who's been subjected to this kind of conduct. Why do I say that? Well, the reality of gender-based violence, as you can imagine, is that it's often a very traumatic event or series of events. And as such, the person who is on the receiving end of this particular behavior is going through a range of emotions, many of which are linked to trauma. And so what they need in dealing with these set of issues is not necessarily sort of an aggressive or combative or accusatory approach. Rather, what they need is somebody to be leading with compassion, leading with gentleness, and leading with openness. Ultimately, the process is going to be potentially long and complex. And so leading with that particular approach is more likely to engender or give rise to the person going through a process that not only is appropriate and relevant and balanced in terms of the various legal processes, but also inflicts the least amount of trauma or further trauma to that person. When it comes to gender-based violence issues, like many gendered issues, there can be a lot of assumptions and stereotypes about these issues. And the reality is that we get many of those stereotypes, sometimes from media, sometimes from family, just sometimes from the world. But regardless, there are stereotypes and assumptions. And when dealing with these issues, it's really important that, frankly, we dispense many of those assumptions. The reality is that in dealing with somebody who's been subject to this particular kind of set of issues, there is no consistent approach or consistent behavior or reaction to being subjected to violence, right? So sometimes people make the assumption that the person who is the complainant, or as we also use the term reporter of gender-based violence, will engage in any of the following: that they will be crying or silent or shaking. But the reality is trauma presents itself in a variety of ways. Sometimes people who've been subject to these kinds of experiences can engage in what is sort of prototypical behavior in terms of what people assume is prototypical behavior, which is crying. But sometimes it can manifest itself in silence. Sometimes it can manifest itself in anger. And to be clear, anger is also an appropriate response, right? Sometimes part of the nomenclature or the narrative around, in particular, how women behave is that women shouldn't be angry when something bad happens. In my view, in terms of the work that I do around human rights work, I often say to folks that anger is an appropriate response to that which somebody says is injustice, right? So anger can be quite a normal response to gender-based violence issues. Another response can also be literally shutting down or disassociating. So in other words, literally somebody retracts so much as though they've kind of withdrawn into themselves and they've just sort of evaporated in a sense. So there's a broad spectrum of approaches or coming from the individual who's on the receiving end. And sometimes somebody can toggle through any and all of these responses in different periods of time. So just keep that sort of present in your mind when encountering somebody who may have been subject to this kind of behavior. Next slide, please. Okay, and so in dealing with these particular issues, and we all have a role in terms of the issues, and different people, depending on what your role is in a university or an organization, may have a different role. When it comes to somebody who is a bystander, that means, in other words, somebody who may be directly witnessing the gender-based violence issue, you have a sort of either potentially statutory role, depending on which particular jurisdiction you're in, or role vis-a-vis a particular policy, or at least at a minimum, probably a moral role to potentially do something and or say something. Well, what do I mean by that? When I say you have a role to do something and or say something, I want to start with the first caveat. The caveat being, it is not always necessarily safe for you to do so. So there are times in life, as I'm sure we all know, when we've seen bad things happen just out in the world, where it is quite appropriate and quite safe for you to stand up and say something in the circumstances. And there are other circumstances in which if you do that thing, it will be completely unsafe for you to do so. The better approach might be for you to extricate yourself from the situation and go and tell somebody else who is better equipped to do something. So you're going to need to make an assessment based on the circumstances you're in. But in many instances, people assume that they shouldn't do something and they're actually well positioned to do something. And on the issue of the bystander and doing or saying something, that doing or saying something doesn't always necessarily have to be in the moment. Sometimes the doing or saying of something can be after the incident happened. So case in point, I have an experience that I had about 3 years ago. I was on public transit. There was a woman in front of me on a bus very close to where the driver was. And she had her two children in a stroller. And based on the configuration of that particular bus, there was nowhere else for her to stand. She couldn't help but stand there. And by virtue of the circumstances, she was partially blocking the aisleway. Couldn't be avoided. That's the nature of public transit. A man gets onto that particular bus and sort of rudely says that she should move out of the way. Of course, she can't move out of the way. So she effectively says, I can't really move. And then he then proceeds to literally kick her stroller, right? Which was just astounding, really quite astounding, and continued through the bus. In that moment, right, I was A, frankly shocked. And B, I didn't say something in that moment because it was a moment of violence in which I thought, I don't think it's safe to say something to him. I, however, did say something to the bus, the actual driver of the bus. And when the woman got off the bus shortly thereafter, it was very close to where I had to get off. And I decided I was just going to get off at that point too, so I could have a conversation with her. And so what I said to her was, just so you know, that was not okay, right? That was not okay. And there was another woman who witnessed it as well, who said something similar at the same time. And so we sort of stood there for a moment and engaged with her. We hadn't actually done anything in terms of preventing the violence in the moment because we weren't in a position to do so. But in that moment, I could tell that that was something for that person. Because she said thank you and she sort of expressed gratitude. So again, the role of a bystander is powerful. You're not always going to be able to do something quite substantive, but sometimes just the acknowledging that a bad thing has happened is monumental in someone's life. So that's why that's important. Next, on the issue of the role of people in these gender-based violence issues is the role of colleagues and peers in workplaces. So again, as a colleague or peer, you may literally witness the gender-based violence issue that happens, or you may have been told about it by the person who is subject to the incident. So whether you're either the person who witnesses it or told about it, you are probably going to have some sort of role in this particular process as it pertains to an investigation process. Meaning, at some point in time, you may be called upon to be a witness because you literally saw what happened, or you may be called upon to be a witness because you were the first person that was told about the thing that happened. In any event, you should be aware of that, and potentially, if you are a unionized worker specifically, you might want to get some specific advice about that and what that means for you in terms of your role, because the reality of being a colleague and a peer is sometimes your role is best to be a supportive role in terms of continuing to listen to your colleague as they talk about what happened. And sometimes, even though that is a natural and human thing to do, it's not appropriate for you to continue to engage with that person because you're a witness, and your witness testimony can be compromised by the fact that you keep engaging with the person who was subject to the behavior. So again, this is something that you're going to need to get that advice on if you're a unionized worker who is a part of a process whereby you've been a witness or somebody who has been told about an incident that's happened. Next is the role of managers or supervisors. Managers or supervisors, realistically, depending on no matter which particular statutory regime you fall under or what particular policies and procedures are in place, it's highly likely that you have a legal obligation to do something once you become aware of the incident. Simply saying, well, you know, I mean, I'm not really sure it's my business or my role, it's probably not going to be sufficient as a matter of law or a matter of policy or both. And so you probably have a positive obligation to do something. To that end, if you're a manager or a supervisor in a unionized environment, you likely have access to to an HR representative, labor relations representative who can give you legal advice on that, you should be speaking to them because this is not something you can just think, I can just put off. It's not, these kinds of issues are not put off issues. They engage quasi-criminal aspects as well as potentially criminal aspects. And they also engage potentially significant institutional liability if you as a manager or supervisor didn't do something. In other words, when I say institutional liability, I don't just mean an award at a human rights tribunal. I mean literally a fine from a prosecuting body which says thou should have done something and you didn't, and therefore we're levying a fine of $50,000 to the organization because they didn't. So to be clear, doing something is key, and ultimately if you're a manager or a supervisor in a unionized environment or even a non-unionized environment where it's a workplace, namely a university, you would still have access to that legal advice by virtue of HR. So using it is key. Next slide, please. Okay, so I've talked about investigations high level. What exactly is an investigation, you may be thinking, right? I've heard this term used, what is it? An investigation ultimately is a system whereby an individual such as myself or an internal investigator that's employed by a university or an organization looks into what happened. And the exercise of looking into what happened looks like the following. It looks like first getting the complaint from the reporter, and I'm using that term quite consistently because part of the changing nomenclature around violence issues and agenda-based and is that we call the person who's done the reporting the reporter as compared to the complainant. I put both terms on the slide because both terms are used interchangeably depending on who the investigator is. We get the complaint and then we're hired to then look into it, right? And that it looks like meeting with the complainant or the reporter to find out literally what happened, right? We're going to engage with them in a series of questions to find out what happened. And then we're going to put together a summary of allegations document, which is basically an abridged version of what they say is their key allegations. And then we provide that to the respondent in advance of meeting with the respondent. We then meet with the respondent, right? The respondent gets an opportunity to obviously respond to the allegations that have been made about them. And in doing that, they're going to not only respond to the specific allegations, but they're probably going to give us some more context that we may not have been privy to concerning the circumstances around that particular incident or set of incidents. We then gather from both the complainant or the reporter, as well as the respondent, documents, and documents should be read quite loosely. Documents can mean a lot of different things. It can mean, text messages, WhatsApp messages, social media messages. It can mean photographs, screenshots, handwritten notes, you name it. Documents can mean a lot of different things. It's a pretty elastic term. We collect all of that evidence. And then we also find out from the various parties, who should I be speaking to in terms of who may have witnessed this? We make an assessment on whether or not all of the people who've been listed should be spoken to. And to be clear, just because you name 10 people as witnesses doesn't mean we interview 10 people. We interview the people who are relevant, which is not always the same consideration that either the respondent or the complainant / reporter thinks are the relevant people. We as the investigators have to make our best assessment on who's relevant as a witness. We meet with them, we engage them in questioning as well. And then part of what is key about an investigation process is conducting follow-up interviews. Why is that? Well, in meeting with witnesses and meeting with a respondent and meeting with a complainant or a reporter, we're going to get information that may be new. And we may need to sort of put that new information back to a witness or a respondent or a complainant. And so as a matter of something called procedural fairness, it is only right and just that somebody gets a reasonable right to respond to new evidence that there wasn't before them before. And so that is why we conduct a follow-up interview to say, well, when I was speaking with so-and-so, they said such and such, what say you, is effectively the exercise of a follow-up interview. After all that's happened, we generate a report and it's provided to the client, namely the university, and that's that particular piece. Next slide, please. Okay, so as I said, that process obviously of doing the investigation looks like asking questions. One of the things, or two of the things that I think it behooves me or is incumbent upon me to mention is the following. At times, people are sometimes perplexed by the questions that an investigator asks. And I routinely say as part of my opening remarks is I say two things. I say, my job is to go where the evidence takes me. And so at times that's going to maybe look like me asking you questions that you may think, you know, oh, is that relevant? Why is she asking me that? And so, you know, my view is that we need to sort of do the digging. I mean, an investigation is literally sort of the definition of that is to look into or to find out, right? And so in order to do that, I have to sort of, you know, pull at times threads that may to you seem tangential, but to me are relevant in terms of the inquiry. And so it's better to be thorough to get a good sense of the landscape of the context instead of just getting partial information. So that's the why behind that, right? Also, investigators have to sort of actively listen, right? And in doing that active listening, sometimes it becomes clear that somebody's only partially answered a question. They think they've answered it when they really haven't. They've spoken about the question, but haven't actually answered the question, right? And we do all that because the exercise of an investigator is to ultimately take the evidence, collect it, and weigh the evidence, and then come to a conclusion, right? As a neutral third party, that's the role, right? And so I'm on nobody's side. My goal is to fundamentally find out what the truth is and what a conclusion is that I should make based on the evidence I have in front of me. Next slide, please. Okay, investigators. As I said, we're neutral third parties. And to be clear, when we're brought in to look into allegations, it may be gender-based violence related, but it's also important to note that when it comes to these particular issues, gender-based violence issues are often intersect with other human rights-based issues. So for example, gender-based violence may intersect with race. It may also intersect with disability. It may also intersect with sexual orientation. The reason why I mention that is because that adds a layer of complexity to these issues, because the investigator has to consider all of those factors when looking at this particular set of issues, right? As I frequently say in the work that I do, whether it's training or mediations or investigations or providing advice, as I say, you know, the reality is the experience of, say, a white woman in the world is going to be different from, say, a South Asian woman. It's going to be different from a Black woman with a disability, et cetera, et cetera. So we all come to the world differently depending on our various identities. When it comes to being an investigator, of course, we're no one's advocate, but, you know, I often remind people of that because at times you as an investigator, you know, strangely enough, are accused of being biased on either side's favor. Sometimes people accuse you of being biased on in the favor of the complainant or the reporter. Sometimes people accuse you of being biased in favor of the respondent or what they assume to be the clients or the universities or the you know, the institution's position. To be clear, that's just not the case. And part of what makes, you know, investigators neutral in what they do and sort of evidence of that neutrality is the following. We as investigators, not only in my own firm, but in other firms, consistently find that no matter where we land on our investigation reports, we get recommended by former clients, right? And we get reused by former clients, even if we render a report that presumably is not in their favor, whatever that means, right? So that's important to understand in terms of the role of an investigator. Next slide, please. Okay, in terms of the forms of gender-based violence issues, this has been alluded to by Brenda, and I'm going to touch on it very lightly, and then wrap up. So obviously, and then, you know, these matters arise by virtue of an internal complaint that's happened in terms of what a worker may have experienced. The investigation happens either internally or externally, but you should be aware of the following. The reality is that when it comes to gender-based violence issues, there are multitudes of forums where these issues are dealt with, and often they can be happening at the same time. So in other words, you may bring on an investigator to look into the investigation. At the same time as the incident happened, the union filed a grievance, and that might be making its way through a grievance step process and sort of moving along in that journey. the individual employee, either with the knowledge of the union or without the knowledge of the union, may have filed a complaint at a human rights tribunal or commission, depending on your jurisdiction. And there might also be a court process, either civil or criminal, that's all in play. So all of these things might be going on simultaneously. At certain points in time, some of the processes might be put into abeyance because there's another process going on. But I say all this to say that there's layers of complexity. Each particular forum has its own particular purpose, which has to always be kept in mind. And what's important as well for not only the complainants or the reporters, the respondents, but also the institutions to remember, and also, frankly, the union representatives, as well as any support persons who may be present with either a reporter, a witness, or a respondent, is that just because you may be familiar with one of the other processes doesn't mean a workplace investigation process is the same thing. So what I have to do from time to time is remind legal counsel, as well as union representatives, that I know that you're an advocate. Your role is to advocate in the context of grievance arbitration. Your role is to advocate in front of human rights tribunals or courts. However, this process is quite different, right? This is a process of me asking questions. And so the role of the union rep or counsel is not to sort of make objections all the time or provide evidence on their client's behalf. It's mostly just to be a note taker and a support person to their particular client or member. Next slide, please. Okay, and so very quickly, and I think this is my last particular slide, when it comes to all of these forums, like I said, they have different purposes. Grievance arbitration is clearly for unionized employees, and it's an adjudication process. Human rights tribunals or commissions are not only for employees, but they're also typically for customers, students, and members of the public who may have been engaged in a gender-based violence issue on some level. And then courts are either criminal or civil processes that are triggered by virtue of things such as a terminated employee or workplace safety legislation or workplace safety and insurance legislation as well. So that's, as I said, a very go lightly coverage of all things workplace investigation related. And as I said at the outset, I commend you to some of the resources that will be provided at a later date that can provide you with a bit more information, because there's lots to know about workplace investigations.
Wonderful. Thank you, Brenda. Thank you, Essie. And now I'd like to invite our attendees to share questions and comments, and you can do so by typing these into the Q&A box at the bottom of your screen. All right, so I think we've got our first question. And so this is for Brenda. Brenda, can you elaborate on how a union handles cases where both the complainant and the respondent are represented by the same bargaining agent?
I think I can. What I know that I don't run grievances. I've never been a grievance officer, but I know the process. And the process goes something like this. All grievances are grievances launched against the employer, including a grievance that might involve a respondent and a complainant who are members of the same union. The grievance is still launched against the employer. Often the claim of the grievance is that the employer has violated the obligation to provide a safe workplace. And so very much, it's not an investigation in the same way that Essie would do her investigations, but grievance officers, usually there's at least one, if not two, per local, if your local has that capacity in their executive committee. And there is one person appointed to be the officer or the steward who works with the complainant, and another person works with the respondent. And the key to giving both union members access to a fair due process grievance process is to separate those spheres of information. That is, to make sure that the people working with the respondent on one side and the complainant on the other, when it comes to launching that grievance, do not speak to each other, and that the complainant and the respondent do not speak to each other within the confines of the union space. So, for example, what might happen is that a complainant calls a union office, wants to talk to a grievance officer, wants to launch a grievance against the employer for failing to protect that person. there would be an appointment set up and in a different part of a building. So this separation goes to sort of physical space. It goes to making sure that a respondent and a complainant are not in the same place at the same time, that they're not talking to these two different people in the same building at the same time, that notes on the conversation with each of these separate people are indeed filed in different physical spaces and locked. So it's that kind of thing. So from the moment that somebody calls a union office and says, I need representation from my bargaining agent, to the moment that the grievance is formally launched against the employer, there would be this maintenance of a separation between the two members. So they would never be brought into contact by officers or agents of the union. Hope that helps a bit.
That's great, thank you. I know we've got a number of questions in the Q&A box. Essie, is there one that you'd like to answer?
Sure. So I have the following question, it is as follows. What is your opinion or advice on the best approach when the party, sorry, in the GBV investigation wishes to have both a support person and a union representative attend the interview? So I've had a similar kind of thing happen with me in a number of investigations, which is in effect the person's asking for two representatives, right? I don't take issue with that because ultimately, whether it's two union reps because there's a national union rep and a local union rep, or there's two union reps because one's being trained and the other one's the more experienced rep. I don't take issue with that, and frankly, it hasn't really been a problem. Ultimately, having two people present in that particular interview, if it's going to lead to greater comfort for the person who is being interviewed, then great. And I'm not particularly fussed. I just simply remind folks about their obligations around confidentiality, etc., and we carry on. So it typically hasn't been an issue, and I take no issue with it because ultimately, if it leads to a better outcome, that's a good thing both for the complainant or reporter as well as the process. And I think there was another question as well, which is what, in these investigations, is the level of evidence balance of probabilities or does it vary? So the reality is in investigations, the standard is probably always going to be balance of probabilities because that's really just sort of the civil standard. And when it comes to investigations, the reality is though, you know, in terms of whatever the circumstances that are presented to you, you're going to try and get at whatever is the best possible evidence in the circumstances. And you're going to have to weigh that depending on what the nature and scope of that particular evidence is. But ultimately, it's going to be a balance of probabilities type standard that you're going to be engaging in.
That's great. Thank you, Essie. There's another question in here that asks about how some collective agreements include clauses that say that PSIs can't keep any traces of a complaint, a sexual violence, gender-based violence complaint against any staff member for more than 2 years after the complaint has been dealt with. And they're wondering if you have any thoughts on that.
I think many collective agreements have what's called a sunset clause. So when somebody has been, say, disciplined or complained against for some purpose or for some reason, there's a report or it's gone through the grievance process, there's a decision, there could have been sanctions of some sort or disciplinary action, and then it's filed. And then after so many years, could be 2 years, could be 3 years, could be 5 years. I think it really varies from collective agreement to collective agreement. Essie may know more about this because my sense is that sometimes those timelines differ, but often there's something called a sunset clause. And when the sunset clause arrives 2 years after, 3 years after, 5 years after the incident, then the files are destroyed. So if it's been agreed to, then I see no reason to take issue with the agreement. Usually, if these sunset clauses are in a collective agreement, it means that people have come to a mutual agreement, a mutual recognition that this is an appropriate timeline. So both management and the union have hit upon that particular point of time. So I think what people come to an agreement with at the table is what should obtain.
Yeah, I'll jump in on that as well. So, you know, I agree on the whole with Brenda in terms of what she just said. So the reality is those kinds of processes are often a function, again, of the sunset clause, right? So sometimes the sunset clause might be 18 months, sometimes it might be 2 years. And so it's on some level driven by that. It's also driven by the related point, which is the sunset clauses are connected to the larger principle, which is the passage of time makes it harder to look into any allegation, let alone a gender-based violence allegation, because of fading memories, lack of documentation, what might be no longer a particular statutory requirement to have retained documents, etc. That said, though, the reality is, I think, you know, as we're getting heightened awareness around these issues, not only gender-based violence issues, but race issues and other kinds of, you know, human rights issues, sometimes organizations are being more elastic about those timeframes, sometimes, but not necessarily, right? And so the challenge is, you know, while an organization may choose to say, yes, this is a historical issue, it goes back 7 years, the reality is the investigator handed that file, or the Human Rights Tribunal handed that particular file, there's going to be some significant challenges in terms of weighing that evidence and assessing it, because frankly, with the fading of memories, the lack of documentation, etc., while the incident may very well have happened, it's going to be hard to be able to establish that based on all of those factors that I alluded to.
Great, thank you so much. So next question is from Chantel, who is wondering, Brenda and Essie, what you might recommend in terms of addressing situations in which members who are professors or TAs who are involved in harmful relationships with students that involve abuses of power.
I don't know which one of us would like to start. I could start by saying it's one of the first things one would want to figure out is whether there was an institutional policy governing those relationships. In the absence of any kind of institutional policy, or in the absence of, say, an article in a collective agreement that explicitly forbade those relationships, I think one would need to figure out the standing, the ground on which to stand from which to launch a complaint. But Essie may have a different perspective.
No, I think that's about right, because the reality is, depending on a collective agreement and policies, et cetera, which, as we all know, can vary from institution to institution, there may be either an explicit recognition of what is an appropriate or an inappropriate relationship as between a TA and a professor, or there may also be language that is frankly just silent on the issue, or language that on some level is permissive, right? And so depending on the language you're dealing with, you're going to have to fit yourself under that particular regime. And so that's where you're going to need to sort of get the advice from the union, if you're the TA who's a part of this, as well as frankly the professor, because the professor is probably unionized, around what does this mean, right? So this is the set of circumstances based on the framework we have in terms of policies, collective agreements, and also the statutes that are in play in your jurisdiction. That's also another driving force. And I should also say, not only for this question, but frankly for probably many of the other questions that we've addressed, as well as our content. What a policy says around gender-based violence issues, as well as human rights issues, as well as workplace investigations issues, if it's done well, should be directly linking back in terms of where it's getting all of its concepts from the jurisprudence or the case law arising out of the human rights bodies in that jurisdiction. So in other words, it should be compliant with what the case law and statutes say. And so there should be an alignment. And so if you're aligning yourself under a policy, that should nicely kind of dovetail with statute and case law.
That's really helpful. Thank you. So I think we've got time for perhaps 2 more questions. So maybe a question for each of you. Essie, if folks are wondering how So the question is, how do you maintain your neutrality when you're doing an investigation?
Sure. So that's a question that sometimes comes up from time to time around, people sort of, either wondering or making assumptions based on a variety of things around whether or not I am neutral based on who knows what, right? Based on assumptions, based on where I've worked before, where I currently work. And even frankly, I've had in previous instances, assumptions just based on my gender and or race. And part of what I always say to folks around that particular issue, if it comes up, is I say the reality is, the work of deciding when it comes to an investigation is neutral work. We go where the evidence takes us, we look at it all, and we make the inquiries and we weigh it. And part of the weighing of evidence and looking into things is a function of understanding what the case law says about what is best evidence and what the case law says is around neutrality. Secondly, when it comes to the issue of neutrality, I'm not beholden to anyone when it comes to the investigation work. I'm not beholden to a complainant. I'm not beholden to the client, who is typically the university. I'm not beholden to the respondent, and I'm not friends with anyone, right? So I don't have any stake in any of this, and by virtue of the way I do the work and the way I'm confident that most investigators do the work, we're not personally invested in an outcome. We're invested in doing a good work product, right? So we're not invested in it going this way or that way. We're invested in finding the truth, much as other people that do investigation type work are as well.
Great, thank you, Essie. And Brenda, the question for you is, if you could speak a little bit to the possible friction between trauma-informed approaches and collective agreements.
Yes, I think I also see another question that almost that kind of touches on that too. How could the grievance process perhaps be made more trauma-informed? And I think education and training is part of this. And I think that's where unions also have to take on more of this work, in the sense of bringing kind of the compassion and those qualities of active listening that Essie was talking about in terms of investigations. Unions don't do the kind of investigations that Essie does, but I do think that working with people through the grievance process in a way that is respectful and compassionate can address some of those perceived gaps. And I think that what people might not realize about the grievance process, because I did see another question about this, the grievance process is always launched, a grievance is always launched against the employer for violating something in the collective agreement. So when it comes to a trauma-informed grievance process or survivor-centered grievance process, the grievance process is there to essentially protect the collective agreement. And the people who are on either side of the grievance itself, the union member and the employer, are parties to the agreement. And the union is committed to respecting the agreement and getting the employer, making sure the employer too respects the agreement. So there's nothing cruel about it, but it can strike people as startlingly perhaps impersonal at certain points, because you are not saying so-and-so is right or so-and-so is wrong or so-and-so did or so-and-so didn't. You're saying, in respect to Article whatever, 99 of this collective agreement, this particular item has been, we think, violated. And so we're coming to you, employer, alleging that you've violated this agreement, which in this case was supposed to keep this person safe. And this person was not safe. And you had an obligation to follow through. And that's why we're filing these papers. So there can be something, I think surprisingly to some people, kind of technical about grievances that is not the same as perhaps some facets of an investigation. Essie's nodding, so she may have more to say.
I agree with that. Yeah.
Can I answer one more question that I see in the
Absolutely.
chat?
Yes.
Someone asks about, I think I opened with comments about ensuring a safe workplace. And I have an opportunity to clarify what I meant. And that is the union, through the grievance process, has a tool in order to remind the employer quite forcefully and energetically at times of the employer's obligations. So when I talk about ensuring a safe workplace, it's not that the union ensures a safe workplace, it's that the union can file that grievance again against the employer and say, employer, it's your duty to ensure safety in the workplace, and you didn't do that. We think you violated your agreement with us. And so we're using the grievance process as a lever to bring your attention to this alleged violation, and we seek redress.
Okay, wonderful. We've had a really great discussion today. So Brenda and Essie, thank you so very much for sharing your time and your expertise with us today. We've learned a lot, and the recording will be available on our website in a few days. I also want to thank our participants for joining us and for sharing with us today. We appreciate and take inspiration from your commitment to addressing and preventing gender-based violence in your campus. We feel very lucky to be able to work alongside each and every one of you. So thank you for joining us, and a kind reminder to please complete the evaluation forms. Oh, and don't forget that registration is now open for our National Skillshare series. And it's a great way to continue the conversations that we've been having as part of our webinar series. And our National Skillshare series in particular will highlight the really groundbreaking work being done across Canada to address gender-based violence on campus. We'll be showcasing the 15 tools and toolkits being developed by 150 plus project partners, including our communities of practice. So you can sign up on the Courage to Act website, and the next one is on February 10th. And we're hoping to see you all there. So thank you everyone for a really great discussion today.
Thank you. Bye-bye.
Thank you.
Bye everyone.
Thank you. Take care.
Of this and other webinars from Courage to Act. Thank you very much.
I agree. Thank you.